Hello and welcome back to our special lecture series on the subject of constitutional law. My name is Taimur Khan and I'm an attorney at law. It brings me great joy to learn about some of the feedback that we have received, as the ultimate purpose of putting out all of this content is not just to help the students of constitutional law, but to provide an easy access from where everyone could better understand the constitutional as well as the political history of our great nation Pakistan. So today we are going to cover yet another important constitutional case, the famous Haji Saifullah Khan case. And some of the cases which we will refer now would be dealing and pertaining to Article 58(2)(b), which was an article which gave a right, a discretion to the President of Pakistan to dissolve the National Assembly and to dismiss the Prime Minister. But before we get to this case, very quickly I would give a rundown of some of the important turn of events that happened from where we left off earlier. So previously we talked a bit about the Begum Nusrat Bhutto case and the Law's Continuance in Force Order of 1977, which was promulgated on the 5th of July, whereby the Constitution of 1973, unlike the previous practice, wasn't abrogated, but it was held in abeyance. And General Zia promised the nation that he would hold elections by October 18th of 1977 and that he had no plans and he had never wanted to lay claim to power. However, once this date crossed, he said that elections won't be held till such time that the whole process of public accountability has come to a complete, which would take at least 6 months. Then he again reneged and said that till such time that there is sound economic base and when there are positive results. And then later on again he said that till such time that local government elections are not held. So finally now elections were due to be held by November of 1979. But just by October 1979, few months before, General Zia again reneged on his promise and banned all the political parties, dismissed the whole process, and elections were postponed indefinitely. And it is during this time frame that for the first time military courts were given constitutional recognition under Article 212 of the Constitution. There were certain other presidential orders which had the effect of taking away the power of judicial review that had been reserved by the superior judiciary under the Begum Nusrat Bhutto judgment. Rolling the clock a bit forward, in the year 1981, the Provisional Constitution Order was given, which outlined the sort of features upon which the country now was to be governed, as the law's continuance in force was just a stopgap arrangement. So afterward, General Zia said that there were three options of moving forward. A, we could either restore the previous constitution in its original form. B, we could abrogate it and come up with a new one. Or C, we could restore the previous one but with certain slight changes. So now when the first elections were held in the year 1985 on non-party basis, before the new assembly could meet up and Haji Saifullah was now to be sworn in as the Prime Minister, a revival of Constitution Order 1985 was issued, which had the effect of giving a whole facelift to the Constitution. Many changes were made. Chief among them were Article 2A, whereby objective resolution was now to be considered as substantive part of the Constitution. And a new Article 58(2) had been introduced, which gave the power to the President to dissolve the National Assembly. Certain changes were made before this could be given constitutional recognition through the 8th Amendment. And then finally, when the 8th Amendment came, this article now was reserved as Article 58(2)(b). In the year 1985, Junejo's government was dismissed by General Zia using his powers under Article 58(2)(b), where the language stipulated that where a situation has arisen in which the government of the Federation cannot be carried on in accordance with the provisions of the Constitution. And so the Junejo's government was dismissed on various set of grounds, namely that the law and order situation had deteriorated, that the life and liberty of the subjects of the people was in question, and that the National Assembly had really lost the purpose for which it was to be set up. And this measure of General Zia was later challenged by Haji Saifullah Khan. Haji Saifullah Khan was a member of National Assembly who challenged the order of General Zia under Article 58(2)(b) before the Honorable Lahore High Court, and he was mainly asking for two reliefs: that the order itself should be set aside and the assembly should be restored. Now, the Lahore High Court did set aside the order, however it did not restore the assemblies. And so against this order of Lahore High Court, both parties preferred to file an appeal before the Supreme Court, and the ultimate opinion was written by Justice Naseem Hasan Shah. Now, before the Honorable Supreme Court, there were two main fundamental articles, the interpretation of which was critical in resolving the whole case altogether. There was Article 48(1), which stipulated that in the exercise of his functions, the President shall act in accordance with the advice of the Cabinet, the Prime Minister, or any other appropriate minister. Article 48(2) said that notwithstanding anything contained in Clause 1 of Article 48, the President shall act in his discretion in respect of any matter in which he has been empowered by the Constitution to do so, and the validity of anything as such shall not be called in question. Now, the other article was Article 58(2), which started with a non-obstant clause. Again, it said that notwithstanding anything contained in Article 48(2), the President may also dissolve the National Assembly in his discretion wherever, in his opinion, a situation has arisen in which the government of the Federation cannot be carried on in accordance with the provisions of the Constitution, and an appeal to the electorate is necessary. Now, the whole problem was with respect to the interpretation of the non-obstant clause, which was appearing in the language of Article 58(2). What does it mean? The learned Attorney General firstly argued that this is just a clarification, because under Article 48(2) we have clarified that the President can exercise discretion in matters without the advice of the Prime Minister where he has been empowered, and the language, the non-obstant clause being employed in Article 58(2) only reinforces the principle that the President can do so without the advice of the Prime Minister, and he has been empowered, and so presidential immunity as such, to the extent that his action should not be called in question, should be given. However, the petitioners contended that this is taking away the powers, that this is operating as a restriction, and the restriction which is being imposed is that the immunity of his action, which he enjoyed under Article 48(2), has been excluded expressly by the use of the non-obstant clause. So now, in dealing with this sort of dilemma, the Honorable Supreme Court relied on the debates which were made on the floor of the National Assembly at the time when this article was being pressed in service within the constitutional framework. And so when they looked at the debates, they saw that initially Article 58(2) existed in the form of the provision which was given under the RCO, the Revival of Constitution Order 1985, where 58(2) said that the President may dissolve the National Assembly in his discretion where, in his opinion, an appeal to the electorate is necessary. The language was very simple, and so much power was given to the President, and so they even produced the extracts given by the Prime Minister on the floor that we need to make this process a bit more cumbersome. And so they added certain other provisions. They started off with the non-obstant clause and said that where a situation has arisen in which the government of the Federation cannot be carried in accordance with the provisions of this Constitution, and an appeal to the electorate is necessary. And so the purpose of reviewing all of these debates was to see the intention of the lawmaker, which was that the power of the President should be curbed. And so the ultimate effect that the court ruled was that the immunity that the President enjoyed under Article 48(2) would stand excluded, and any such order can be judicially reviewed by the Honorable Supreme Court. The second point the Honorable Supreme Court made was that first the President has to form an opinion. And if, for the sake of academic discussion, if certain immunity is given, it would only be exercisable against discretion and not the formation of opinion. The formation of opinion would be the condition precedent, which has to be based on certain materials. It has to bear nexus. And so when they looked at the respective turn of events and the grounds which had been given by General Zia in his Article 58(2)(b) order that the life and liberty of the people was in danger, that the security situation was in shambles, that the National Assembly had lost the utility. The Honorable Supreme Court reviewed all of these orders and said that there was no material from which the President, the late President, could have argued, could have thought that in his opinion such a situation has arisen. And so the grounds, since they didn't bear nexus with the actual materials on ground, the Honorable Supreme Court decided to support the earlier judgment of Lahore High Court in terms of concluding that this order which had been issued did not meet the criteria as was specified under Article 58(2)(b). Another important question again now was with respect to the restoration of the assemblies. And so the Honorable Supreme Court said that since a new election schedule has already been announced and that all the political parties have already given their acquiescence that they would be contesting the elections, and since the earlier elections of 1984 were held on non-party basis where the Movement of Restoration of Democracy comprising of Pakistan People's Party and other parties had not participated, so this would be a good move for other parties to participate in these new elections. And so if we were to restore the assemblies, it would perhaps do injustice than anything else, given that the position of Pakistan Muslim League had also changed. And so the ultimate Supreme Court ruling was in stricto sensu the same as was given by Lahore High Court, but given with certain other changes. The Supreme Court bench that heard this case comprised of some 12 judges, and all of them were in agreement with the opinion which had been authored by Justice Naseem Hassan Shah. However, Justice Shafiur Rahman decided to add his own separate note. And so the main point he made was that the expression "cannot be carried on" was sandwiched in between the federal government and in accordance with the provisions of the Constitution. So there had to be a very potent and a clear meaning. Nothing was left to surmises or conjectures, and that the respective provision which had been added through the 8th Amendment was actually talking about a deadlock, a stalemate, that the breakdown of the constitutional machinery has been brought about. And only that would, as such, warrant for taking such a drastic action by the President in exercise of his powers under Article 58(2)(b). On the question of restoration of assemblies, he again agreed with the majority opinion which was given by Justice Naseem Hassan Shah. And he also added that the High Court, in exercise of its constitutional jurisdiction, can also take into account the larger public interest. That it isn't the case that always relief has to be given in view of that being claimed by one party, but if the larger public interest would not be served by issuing and by giving effect to the prayer, then the High Court may have to decide accordingly. In addition, there were also certain questions about political question doctrine. However, keeping in view that if there is a violation of a constitutional provision, the court would never be precluded from just this political question doctrine from actually deciding this case on merits. And so the opinion, this special opinion of Shafiur Rahman, was also referred to later on Khwaja Ahmad Tariq Rahim case, which is what we will cover in our next lecture. And so we're going to cut short our lecture here today, and we hope that we have covered some of the important issues in this respective case. Thank you.